Mungu twaomba uilinde Jumuiya Afrika Mashariki tuwezeshe kuishi.
My name is Euphnalis Okubo. I'm the Registrar of the East African Court of Justice. This court was inaugurated in 2001 and received its first case in 2005.
The court was established by the treaty as one of the 8 organs of the community, and its basic role is spelled out in Article 23 of the treaty. And the mandate of the court is to ensure the adherence to law in interpretation and application of the treaty and compliance of this treaty. The court has 3 kinds of jurisdictions, technically speaking, and these were elaborated in one of the cases, which is famously known as the Alcon case. Each court has 3 jurisdictions. The first jurisdiction is what is called jurisdiction ratione personae, meaning who was standing before the court. The second jurisdiction is to do with the subject matter, which is called ratione materiae. And the third jurisdiction is to deal with the time limit, which is called jurisdiction ratione tempore. That's temporal jurisdiction. And now, if we go to the first jurisdiction that I pointed out, jurisdiction ratione personae, or who was standing before the court, the treaty provides from Article 28 to Article 34 different individuals or entities which have standing before this court. Article 28 provides that a partner state can bring a complaint against another partner state in as far as breach of the treaty is concerned. Article 29 gives the locus standi to the Secretary General to bring a complaint before this court. In Article 30 gives individuals standing before this court, but on very limited subject matter, and that's the subject matter that an individual can bring a case against either one of the partner states or the one of the institutions of the East African community.
The judges appointed to this court, most of them are also judges in their national judiciaries.
An individual is nominated by his or her country and then appointed by the summit. And the condition is that you ought to fulfill in order to be nominated is that you have to have the experience which allows you to serve in the highest court of your land, or you must be a jurist of high standing in your own partner state, also capable of being appointed at the highest court in your own jurisdiction. So that is how procedure goes on. So nomination by your country, but taking into consideration the factors that I've just talked about, and then appointment by the summit.
We have different kind of cases instituted. We have references, for instance, is one of the cases instituted in the First Assist Division. The other type of case is a claim. Claims are also other type of cases which are instituted.
The important issue is that we know that we are appearing before an independent court, before independent judges and corrupt judges. The one who loses here, he knows that he has lost. The one who gains here, he knows very well that he has gained. We are happy with the way the judges is operating, with the way the court is operating.
The decisions of this court are respected and are complied by partner states, and I can give two examples here. The case of the elections of EALA from Kenya, where the court stopped the swearing in of those members because they did not follow the correct procedure. The matter went back to the National Parliament. They followed the procedure, and then they were able to be admitted as EALA. The other one is a case emanating from Rwanda, where a senior military officer was arrested. He was held in incarceration for a very long time without anybody knowing where he is or without him being produced to court. When the family came to this court to complain about the detention and the unknown location of their relative, the court made an order, and immediately that person was then produced in court. That means the partner states respect the court and they are willing to comply with the orders of the court.
There's a lot of remarkable decisions the court has delivered. If you go to the very first decision of the court, in the case of Mwatela and others versus the East African community, that's when the court was, you'd say that was its maiden coming out. And it was a case that actually ended up pitting up the legislative arm of the EAC, the East African Legislative Assembly, against the Council of Ministers and by extension the member states. It also came up very uniquely with the principle of prospective annulment, where it declared that certain actions that had been taken by the policy organs were wrong, but rather that annulled them, which would have thrown the community into some confusion. It says it only annuls prospectively. So it preserves what has been done, but says in the future, it ought to be done following the rules and the treaty, which I think was very innovative. The case of East Africa Law Society versus the Attorneys General of Kenya, Uganda, and Tanzania was also landmark in that it was the first time 3 African governments had been sued in one case by an African citizen, or anywhere in the world.
The relationship between this court and the partner states is very, very positive. A number of cases have been filed against the government of Burundi, about 24, which means there are many. Which means since we joined the community in 2007, immediately when the people of Burundi, citizens and the residents of Burundi, knew about the court, they filed many cases.
So there are quite a number of matters in the court that have ended, have gone from inception to conclusion inside of 12 months, some 14, 16, and so on, which I think is a pretty good case disposal rate for an international court.
On average, every year, the court receives about between 40 and 60 cases. That does not necessarily mean within that 1 year, all those cases will be heard and determined. So in a year, we may have about 20 or so being determined. In another year, we may have less. In another year, we may have many. But from the time it was established to date, we have an average of almost 200 cases that have been determined to their finality.
In terms of case disposal, again, I think the court has a pretty good case disposal rate. I would say again, the length of time that a case takes is quite often determined more by the litigants themselves than by the court. If the litigants keep time and the timelines, then really what's left to the court is to write the judgment.
We know that this court is very important. We have been appearing, especially after the establishment of the sub-registries in our capitals. And the people know about the court.
You don't really need to come to Arusha to file your case. All you need to do is to go to your capital. We have sub-registries there. We have our system there in those sub-registries. It is linked. The system we have here is linked to our sub-registries. And once you get there, your papers will be processed online. Until here, all you'll be told is that then go and serve your papers because everything has been processed online. Very soon, we are going to be a paperless court. The modern way to go now is to go the e-filing system. So that is why we introduced this system, especially because we are a regional court. The system is working, but it has not completely rolled out to all the stakeholders, including the lawyers and the litigants. Of course, the litigants will go to the lawyers. So our next phase is to roll out this system to the lawyers so that the lawyers can file from the comfort of their offices. It is also a matter of sensitization where we want even the lawyers to have confidence in IT. As you know, many people are always skeptical about IT and they are slow to adapt to it. But it is the way to go. Most other regional courts, other international courts are going that way, and our court is not going to be left behind. Whoever does not accept change will be left behind. That is the direction of the world. That is the direction everything is going. So it may take time, it may be slow, but at the end of the day, they'll have to adapt to it. It is possible to hold sessions outside Arusha, and it has been done before. We have a mobile bit of it that we can move with it if we need to have sessions outside Arusha. And it is something which we are planning. We are going to do it and try and rotate in all the capitals where we have cases, especially cases emanating from those countries. It will be good if we take it there so that the public can also find it easier to come to the court, listen to what is going on, and then they'll be more sensitized about our courts. Like any other organization, I cannot say we do not have challenges. If we had more funding than we are getting, then we'll be able to do more. We'll be able to do more sensitization. We'll be able to have even these circuit courts more frequently going around. That is a major challenge.
The term of office of judges in the EAC is 7 years, which is not renewed. At the very beginning, when the first judges were sworn in, they tried to stagger the terms. Some judges completed their term in the first 5 years, others 6 years and 7, so that all the judges do not go at the same time. However, there is another factor apart from the 7 years, which is not renewed. It's the retirement age of 70 years. It's either 7 years or 70 years, whichever comes first. So at some point, even though the staggering worked well in the initial stages of the court, at some point with the retirement age of 70 years, almost all the judges happen to have gone at the same time. Some courts have a longer term, sometimes 9 years, and at the beginning when they stagger it, because they don't have a second condition of a retirement age, so the staggering allows continuity of judges for quite some time.
Sometimes we might need them to come here urgently for a matter. They may not be available because they're attending matters with the national judiciaries. It will have been good if all the judges were permanently here, then matters will move faster. It is possible, if the judges are here permanently, for the matters to be concluded within 6 months.
This is a historical achievement. Now, when the then administration in Sudan, when we were still one, the British, had wanted us to be part of the North by then, during the independence of Sudan, we refused. We said we are part of East Africa. We have laws, but if you don't know how to implement them, then you have a problem. We have fought for the last 100 years. It is not easy to get to do things in a very civil way. One of the things we are hoping to gain here is the respect for the rule of law. So we hope our brothers and sisters will help us.
It may have been awareness, people to know that certain things can be brought to this court. So it took time before sensitization was done and citizens became aware of their rights that can be arbitrated properly through these courts.
Initially, when the rules of procedures were developed by the court, there was a filing fee whenever you came to file a case with us. But when we amended the rules in 2013, the filing fee was abolished. Now it's free to institute a claim before our court.
You have opportunities here to solve your disputes. You have opportunities here to have your rights upheld. Take advantage of it. Don't fear. Filing fee is free. That should be able to reduce the cost of litigation. Should make access to this court very easy for the citizens of East Africa. And that is the only way we can also promote integration in the region.